I also looked at some of your judgments where you have also ruled on criminalization of politics and how,
Yes. That was a very interesting case. At that time I was in the High Court of Delhi as a judge working, and the presiding judge was another judge, Justice Anil Dev Singh. He later on became the Chief Justice of Rajasthan High Court also, and then retired. So we were sitting together, and that matter came. Somebody had filed that case, bringing to the notice that there are a lot of criminalization in politics. So how can that be rooted out? So when we were hearing, we were thinking as to what could be done in such matters. Then we evolved one way out. So we thought that when a candidate files his nomination for getting elected to the assembly or the parliament, so he has to file his nomination. That is under the Representation of People's Act. So we thought that if now there are a lot of criminalization in politics, there are a number of MLAs or MPs being elected by virtue of their mafiaism and becoming a part of the legislature, but having no education at all. And he is involved in criminal cases also. So we thought that his antecedents with regard to his education, his nature of living, all these must be known to the voter.
Correct.
So that the voter can make a conscious decision when he is exercising his franchise. He makes a conscious decision that he is the right person to be elected. So we evolved a way that he has to, along with the nomination, he has to file an affidavit where he has to state about his background, his educational qualification, whether or not any criminal case is pending against him, mentioning all these in that affidavit. And why we said affidavit? Because then he is bound up. When he makes an affidavit giving he cannot hide anything. When we passed that judgment, now Supreme Court also looked into our judgment and then they upheld our judgment, adding certain more things there. Now, therefore, there is a provision of filing an affidavit along with the nomination papers. But unfortunately, what has happened is, now if any false statement is made in that affidavit, then he could be hauled up for that only under the provision of perjury.
Okay.
That is there, but that is a long process. Perjury, somebody has to file a case of perjury, prove the case, and the candidate will have a number of protections also, because the person who will be filing, he is a voter, maybe a voter. No provision that that person who has given the false affidavit, he cannot be tried in those. So therefore, my suggestion is that there should be some provision in the RP Act, that the Representation of the People's Act, for taking up a matter or instituting a case under the provisions of the Representation of the People's Act for filing a false affidavit. There should be some provision in the Act itself. That's my feeling and suggestion.